Question 1. Benchmark analysis indicates that a landlord in Alberta is experiencing consistent late rent payments from a tenant. What is the most appropriate and legally compliant course of action for the landlord to take to address this ongoing issue, ensuring adherence to Alberta's landlord and tenant legislation? Option A. Accept any partial rent payments offered by the tenant without issuing formal notices, hoping the tenant will eventually catch up on the full amount owed. Option B. Rely on verbal agreements with the tenant regarding payment deadlines and consequences for late payments, as this fosters a more personal landlord-tenant relationship. Option C. Promptly issue a written notice of rent arrears, followed by a formal notice to end a tenancy for non-payment of rent if arrears persist, and subsequently apply to the Residential Tenancy Dispute Resolution Service, RTDRS, or Court of Queen's Bench if necessary. Option D. Immediately change the locks to the rental unit to prevent further unauthorized occupancy, and demand immediate payment of all outstanding rent. The correct answer is C. Promptly issue a written notice of rent arrears, followed by a formal notice to end a tenancy for non-payment of rent if arrears persist, and subsequently apply to the Residential Tenancy Dispute Resolution Service, RTDRS, or Court of Queen's Bench if necessary. Explanation. Scenario analysis. This scenario presents a common challenge in lease administration, managing a tenant's late rent payment while adhering to the specific legal framework of Alberta. The professional challenge lies in balancing the landlord's right to receive rent in a timely manner with the tenant's rights and the procedural requirements outlined in Alberta's Residential Tenancies Act, RTA. Missteps can lead to legal disputes, financial losses for the landlord, and potential breaches of tenant rights, necessitating a careful, legally compliant approach. Correct approach analysis. The best professional practice involves a multi-step process that prioritizes clear communication and adherence to the RTA. This approach begins with promptly issuing a written notice of rent arrears to the tenant, clearly stating the amount owed and the date by which it must be paid to avoid further action. This aligns with the RTA's provisions for addressing rent defaults. If the tenant fails to pay within the specified period, the landlord must then serve a proper notice to end a tenancy for non-payment of rent, following the exact timelines and content requirements stipulated by the RTA. This notice formally informs the tenant of the landlord's intention to terminate the tenancy due to non-payment and provides them with a statutory period to vacate or pay the arrears. If the tenant still does not comply, the landlord's next step is to apply to the Residential Tenancy Dispute Resolution Service, RTDRS, or the Court of Queen's Bench for an order for possession and rent arrears. This methodical, legally prescribed process ensures that the landlord acts within their rights while respecting the tenant's due process under Alberta law. Incorrect approaches analysis. One incorrect approach involves immediately attempting to change the locks or physically evict the tenant without proper legal notice or a court order. This is a direct violation of the RTA, which prohibits landlords from interfering with a tenant's possession of the rental unit except through legal means. Such actions can result in significant penalties for the landlord and may invalidate any subsequent claims for rent or possession. Another unacceptable approach is to accept partial rent payments after the notice period has expired without formally addressing the outstanding arrears and the notice to end tenancy. While accepting partial payments might seem like a conciliatory gesture, it can inadvertently waive the landlord's right to proceed with the eviction based on the original notice, requiring the landlord to start the entire notice process again if the tenant continues to default. This creates uncertainty and potential legal complications. Finally, relying solely on verbal communication to address rent arrears and the intention to evict is insufficient and unprofessional. The RTA requires written notices for significant actions like rent arrears and termination of tenancy. Verbal agreements are difficult to prove and do not meet the legal requirements for serving notices, leaving the landlord without proper documentation to support their actions if a dispute arises. Professional reasoning. Professionals should approach rent collection issues by first understanding the specific requirements of the Residential Tenancies Act, Alberta. This involves familiarizing oneself with the prescribed forms, timelines, and notice periods for rent arrears and termination. The decision-making process should prioritize documentation and adherence to legal procedures. When a tenant is in arrears, the immediate step is always to issue a formal written notice as required by law. If the tenant fails to rectify the situation, the next step is to serve the appropriate notice to end the tenancy. Again, strictly following the RTA's guidelines. Only after these legal prerequisites have been met should a landlord consider applying to the RTDRS or the courts for resolution. This structured, legally compliant approach minimizes risk and ensures fair treatment for both parties. Question 2. Strategic planning requires a real estate professional in Alberta to accurately assess a property's market value. If a client, who is eager to sell their residential property quickly, insists that the property is worth a specific higher amount and asks you to use a valuation method that supports this figure, which approach would be the most ethically sound and professionally responsible to employ, and why? Option A. Employ the cost approach, emphasizing the replacement cost of the property to support the client's valuation. Option B. Utilize the income approach, focusing on potential rental income to justify the client's desired sale price. Option C. Present a valuation based solely on the client's stated desired sale price without applying a formal valuation method. Option D. Conduct a comparative market analysis, CMA, based on recent sales of similar properties in the immediate neighborhood. The correct answer is D. Conduct a comparative market analysis, CMA, based on recent sales of similar properties in the immediate neighborhood. Explanation. This scenario presents a professional challenge because the real estate agent is being pressured to manipulate a valuation method to achieve a specific outcome desired by the client, rather than adhering to objective professional standards. This creates an ethical conflict between client satisfaction and the agent's duty to provide an accurate and unbiased assessment. Careful judgment is required to navigate this situation ethically and legally. The most appropriate approach involves using the comparative market analysis, CMA method. A CMA is a tool used by real estate professionals to determine the market value of a property by comparing it to similar properties that have recently sold in the same area. This method is grounded in current market data and reflects what buyers are actually paying for comparable properties. In Alberta, real estate professionals are bound by the Real Estate Act and its associated rules, which mandate honesty, integrity, and the provision of accurate information to clients. Presenting a CMA that reflects current market conditions, even if it doesn't meet the client's desired sale price, aligns with the agent's fiduciary duty to act in the client's best interest by providing a realistic basis for decision-making. This approach upholds professional standards and avoids misrepresentation. Using the income approach in this context would be inappropriate and potentially misleading. While the income approach is a valid valuation method for income-generating properties, applying it to a residential property where the client's primary goal is a quick sale based on market perception, rather than rental income potential, would misrepresent the property's true market value. It could lead to an inflated valuation that is not supported by comparable sales, violating the principle of providing accurate market information. Similarly, employing the cost approach to justify the client's desired sale price would be an ethical failure. The cost approach estimates the value of a property by calculating the cost to replace it, minus depreciation, plus land value. This method is most useful for unique properties or new construction, and is less relevant for established residential properties, where market demand and comparable sales are the primary drivers of value. Using it to inflate a valuation would be a misapplication of the method, and a breach of professional duty to provide a realistic market assessment. The professional reasoning process in such a situation should involve clearly explaining to the client the limitations and appropriate applications of each valuation method. The agent must educate the client on how market conditions, as reflected in a CMA, dictate a property's likely sale price. If the client remains insistent on an unrealistic price, the agent must be prepared to decline the listing if they cannot ethically represent the property at that price, or clearly communicate the risks and challenges associated with such a pricing strategy. Ensuring all advice is grounded in objective market data and professional obligations under Alberta's real estate legislation. Question 3. The audit findings indicate that a real estate professional in Alberta has a personal financial interest in a mortgage brokerage firm. The professional is representing a buyer who requires financing and is considering recommending this affiliated brokerage. What is the most appropriate course of action for the real estate professional in this situation? Option A. Disclose the personal financial interest in the mortgage brokerage to the buyer only after the mortgage has been approved and finalized. Option B. Proceed with recommending the affiliated mortgage brokerage to the buyer without disclosing the personal financial interest, assuming the brokerage offers competitive rates. Option C. Immediately and fully disclose their personal financial interest in the mortgage brokerage to the buyer, explaining the nature of the relationship and any potential benefits, and allow the buyer to make an informed decision about using the brokerage. Option D. Advise the buyer that using the affiliated mortgage brokerage is a good option for them, without explicitly mentioning the personal financial benefit to the professional. The correct answer is C. Immediately and fully disclose their personal financial interest in the mortgage brokerage to the buyer, explaining the nature of the relationship and any potential benefits, and allow the buyer to make an informed decision about using the brokerage. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the real estate professional to navigate potential conflicts of interest and ensure transparency in a financing arrangement that could benefit them personally. Alberta's Real Estate Act and its associated rules require registrants to act with honesty, integrity, and in the best interests of their clients, while also disclosing any potential conflicts. Failure to do so can lead to disciplinary action and damage to professional reputation. Correct approach analysis. The best professional practice involves full and immediate disclosure of the personal financial interest in the mortgage brokerage to all parties involved in the transaction, particularly the buyer. This approach aligns with the principles of transparency and fiduciary duty mandated by Alberta's real estate regulations. By disclosing the relationship, the registrant ensures the buyer is fully informed and can make an independent decision about whether to proceed with the mortgage brokerage, thereby avoiding any perception of undue influence or hidden benefit. This proactive disclosure upholds the registrant's obligation to act in the client's best interest and maintain public trust. Incorrect approaches analysis. One incorrect approach involves proceeding with the mortgage brokerage without any disclosure. This is a significant ethical and regulatory failure. It violates the duty of honesty and integrity by withholding material information that could influence the buyer's decision. Alberta's Real Estate Act mandates disclosure of any interest a registrant has in a transaction or related service. Another incorrect approach is to only disclose the interest after the mortgage has been secured. This is still problematic as it fails to provide the buyer with the opportunity to consider alternatives from the outset. The disclosure is not timely and does not allow for informed consent from the beginning of the financing process, potentially creating a situation where the buyer feels obligated due to the progress already made. A third incorrect approach is to suggest to the buyer that using the affiliated brokerage is advantageous without clearly stating the personal financial benefit. This misrepresents the situation and can be seen as steering the client towards a service for the registrant's gain, rather than the client's best interest, which is a breach of professional conduct. Professional reasoning. Professionals in Alberta's real estate industry must adopt a proactive and transparent approach to financing arrangements. When a personal interest exists, the decision-making process should prioritize full disclosure to all relevant parties at the earliest possible stage. This involves identifying potential conflicts, understanding the specific disclosure requirements under the Real Estate Act and rules, and communicating clearly and honestly. The guiding principle is always the client's best interest, which is best served by informed consent and an absence of hidden agendas. Question 4. The efficiency study reveals that a property in Calgary, Alberta, with a history of light industrial use and situated near a former municipal landfill, is being considered for purchase by a client. The seller is eager to complete the transaction quickly. What is the most responsible course of action for the real estate professional to recommend to their client? Option A. Downplay any potential environmental concerns to facilitate a swift sale, as the seller is motivated by speed. Option B. Proceed with the transaction as quickly as possible, assuring the client that environmental issues are unlikely given the property's age and the seller's lack of reported problems. Option C. Recommend that the client conduct their own environmental investigation after the sale closes, as this is the buyer's responsibility. Option D. Advise the client that a Phase I environmental site assessment (ESSA) is strongly recommended to identify potential environmental concerns given the property's history and location, and explain the implications of any findings. The correct answer is D. Advise the client that a Phase I environmental site assessment (ESSA) is strongly recommended to identify potential environmental concerns given the property's history and location, and explain the implications of any findings. Explanation. This scenario is professionally challenging because it requires a real estate professional to navigate the intersection of environmental due diligence, client interests, and regulatory compliance in Alberta. The potential for undisclosed environmental contamination poses significant financial and legal risks to both the buyer and the seller, as well as to the real estate professional. A careful judgment is required to ensure all parties are adequately informed and protected. The best professional approach involves proactively advising the client on the necessity of a Phase I environmental site assessment, ESSA, given the property's industrial history and its proximity to a former landfill. This approach is correct because it aligns with the principles of professional conduct and the Alberta Real Estate Association Area Code of Ethics, which mandate acting with honesty, integrity, and in the best interests of the client. Specifically, it addresses the duty to disclose material latent defects and to conduct due diligence. The Environmental Protection and Enhancement Act, EPA, in Alberta places obligations on landowners and those involved in property transactions to be aware of and manage environmental risks. Recommending a Phase I ESA is a standard industry practice for identifying potential environmental concerns without intrusive investigation, allowing for informed decision-making before proceeding with the transaction or undertaking further, more costly, investigations. An approach that involves downplaying the potential environmental concerns due to the seller's desire for a quick sale is professionally unacceptable. This failure to adequately inform the buyer about potential risks, especially given the property's history, violates the duty of disclosure and could lead to significant legal liability for the agent and the seller. It also contravenes the ethical obligation to act with integrity and to avoid misrepresentation. Another unacceptable approach is to proceed with the transaction without any environmental due diligence, relying solely on the seller's assurances. This demonstrates a lack of professional responsibility and a failure to uphold the standard of care expected of a real estate professional. It ignores the potential for significant environmental liabilities that could arise under Alberta's environmental legislation, such as the EPA, which can impose remediation costs and penalties on current owners. Finally, suggesting that the buyer should conduct their own environmental assessment after the sale closes, without providing them with adequate information beforehand, is also professionally flawed. While buyers have a right to conduct their own due diligence, the real estate professional has a duty to disclose known or reasonably discoverable material facts that could affect the property's value or desirability. Failing to recommend or facilitate necessary preliminary environmental inquiries before closing leaves the buyer exposed to unforeseen risks and potential liabilities that could have been identified and addressed during the transaction process. The professional reasoning framework for such situations involves 1. Identifying potential risks and liabilities associated with the property based on its history and location. 2. Understanding the client's objectives and risk tolerance. 3. Consulting relevant legislation and industry best practices, e.g., Area Code of Ethics, EPA. 4. Clearly communicating potential risks and recommended due diligence steps to the client. 5. Documenting all advice and decisions made. 6. Ensuring all parties are informed and have the opportunity to make educated decisions. Question 5. Market research demonstrates that a young couple in Calgary, Alberta, with a stable dual income and a desire for predictable monthly expenses is looking to purchase their first home. They have expressed concern about managing unexpected increases in their mortgage payments. Considering these factors, which mortgage approach would best serve their stated needs and financial prudence? Option A. An adjustable rate mortgage, where the interest rate and corresponding payments fluctuate based on market conditions. Option B. A variable rate mortgage with a low introductory rate without a detailed discussion of potential future rate increases. Option C. An interest-only mortgage, allowing for lower initial payments that cover only the interest accrued for a specified period. Option D. A fixed-rate mortgage, offering consistent principal and interest payments throughout the entire loan term. Correct answer is D. A fixed-rate mortgage, offering consistent principal and interest payments throughout the entire loan term. Explanation. This scenario is professionally challenging because it requires the real estate professional to balance the client's immediate financial concerns with the long-term implications of mortgage choices, all while adhering to Alberta's real estate regulations and ethical obligations. The professional must act in the client's best interest, which involves providing clear, unbiased advice tailored to their specific situation, rather than pushing a product that might seem attractive short-term, but carries significant future risks. The best approach involves thoroughly assessing the client's financial situation, risk tolerance, and future plans to recommend a mortgage type that aligns with their overall financial well-being. This includes explaining the fundamental differences between fixed-rate, adjustable-rate, and interest-only mortgages, and how each might impact their ability to meet future financial obligations. For a client with a stable income and a desire for predictable housing costs, a fixed-rate mortgage offers the certainty of consistent payments over the loan term, mitigating the risk of rising interest rates. This aligns with the Alberta Real Estate Association Area Code of Ethics, which mandates that registrants act with honesty and integrity and place the client's interests above their own. Providing advice that prioritizes long-term financial stability and predictability, even if it means foregoing a potentially higher commission on a different product, is ethically sound and professionally responsible. Recommending an adjustable-rate mortgage without a comprehensive discussion of its variable nature and potential for payment increases is ethically problematic. This approach fails to adequately inform the client about the inherent risks associated with fluctuating interest rates, potentially leading to financial hardship if rates rise significantly. Such a recommendation could be seen as a failure to act in the client's best interest, violating the duty of care owed to them. Suggesting an interest-only mortgage solely based on the client's desire for lower initial payments, without a detailed analysis of their long-term repayment strategy and financial capacity to handle the principal repayment later, is also a significant ethical lapse. This product carries substantial risk, as the principal amount remains unchanged for the duration of the interest-only period, and the eventual repayment of the full principal can be a substantial burden. Failing to fully disclose these risks and ensure the client understands their obligations constitutes a breach of professional duty and potentially contravenes consumer protection guidelines related to financial products. The professional reasoning process should involve a structured client needs assessment. This includes understanding their income stability, employment security, debt load, savings, investment goals, and their comfort level with financial risk. Following this, the professional must educate the client on the features, benefits, and risks of each relevant mortgage type. The recommendation should then be based on a clear alignment between the client's profile and the mortgage product's characteristics, always prioritizing the client's long-term financial security and informed decision-making. Transparency and comprehensive disclosure are paramount throughout the process. Question 6. Process analysis reveals that a tenant in a rental property in Calgary, Alberta, has submitted a written request to keep a small dog, stating it is for emotional support. The property manager recalls the landlord generally prefers no pets, but is unsure if the lease agreement explicitly prohibits them or if there are any specific clauses regarding pets or assistance animals. What is the most appropriate course of action for the property manager to take? Option A. Advise the tenant that they will need to find a new property if they wish to keep a pet, as the landlord's policy is strictly no pets. Option B. Immediately inform the tenant that the landlord's general preference is no pets and therefore the request cannot be approved. Option C. Review the signed lease agreement for any clauses regarding pets or assistance animals, then formally present the tenant's request and all relevant details to the landlord for their decision, and if approved, ensure proper documentation is completed. Option D. Grant the tenant permission to have the dog, assuming that as an emotional support animal, it is automatically allowed under provincial guidelines, and inform the landlord later. The correct answer is C. Review the signed lease agreement for any clauses regarding pets or assistance animals, then formally present the tenant's request and all relevant details to the landlord for their decision, and if approved, ensure proper documentation is completed. Explanation. Scenario analysis. This scenario presents a common challenge in property management where a tenant's request conflicts with the landlord's established policies and potentially the terms of the lease agreement. The property manager must balance the tenant's desire for a pet with the landlord's right to control property use and the need to maintain the property's condition and value. Navigating this requires a thorough understanding of the Residential Tenancies Act, RTA, of Alberta, the specific lease terms, and ethical considerations regarding tenant relations and landlord obligations. Failure to handle this appropriately could lead to disputes, breaches of contract, or even legal action. Correct approach analysis. The best professional approach involves a structured process that respects both the tenant's request and the landlord's rights. This begins with a formal review of the lease agreement to confirm the existing pet policy. If the lease is silent or allows for pets with conditions, the property manager should then communicate the tenant's request to the landlord, providing all relevant details about the proposed pet. The landlord then makes the final decision. If the landlord approves, the property manager should ensure any necessary amendments to the lease or a pet addendum are executed, clearly outlining responsibilities and any additional pet deposit as permitted by the RTA. This approach ensures all actions are documented, legally compliant, and transparent, protecting both parties. Incorrect approach is analysis. One incorrect approach is to immediately deny the request based on a general understanding of the landlord's preferences without consulting the lease or the landlord. This bypasses the contractual obligations outlined in the lease and the landlord's ultimate decision-making authority, potentially violating the tenant's rights if the lease permits pets under certain conditions. Another incorrect approach is to grant permission to the tenant without consulting the landlord or formalizing the agreement. This exposes the landlord to potential property damage or nuisance issues without their explicit consent and creates an undocumented exception to the lease terms, which can lead to future disputes and legal complications. A third incorrect approach is to inform the tenant that the landlord will not consider the request because it is a general policy, without verifying if such a policy is explicitly stated in the lease or if the landlord has the discretion to make exceptions. This misrepresents the contractual reality and the landlord's potential flexibility, failing to follow proper procedure. Professional reasoning. Property managers should always begin by referencing the governing legislation and the specific contractual agreements in place. When faced with a tenant request that may deviate from standard practice, the process should involve 1. Reviewing the lease agreement and relevant legislation, in this case, the Alberta Residential Tenancies Act. 2. Communicating clearly and formally with the landlord, presenting all necessary information for their decision. And 3. Ensuring any agreed-upon changes are properly documented and executed according to legal requirements. This systematic approach minimizes risk and upholds professional standards. Question 7. Process analysis reveals that two siblings, Sarah and David, are purchasing a residential property in Calgary, Alberta, together. Sarah intends for her share of the property to pass to her children upon her death, while David wishes for his share to automatically transfer to Sarah if he predeceases her. They have discussed this verbally, but have not yet finalized the legal documentation for the transfer of title. What is the most appropriate course of action for the real estate professional to advise them on regarding the ownership structure? Option A. Explain the distinct implications of joint tenancy, with right of survivorship and tenancy in common, with separate divisible interests, and guide them to select the structure that aligns with their stated intentions, ensuring accurate registration under Alberta's Land Titles Act. Option B. Advise them to register the property as joint tenants, as this is a common method for siblings purchasing property together, and assume their intentions will be met. Option C. Suggest they proceed with the purchase and leave the ownership structure to be determined later, as verbal agreements are sufficient for siblings. Option D. Recommend they register as tenants in common, as this allows for individual ownership of shares, and suggest they create separate will to address their respective interests. The correct answer is A. Explain the distinct implications of joint tenancy, with right of survivorship and tenancy in common, with separate, divisible interests, and guide them to select the structure that aligns with their stated intentions, ensuring accurate registration under Alberta's Land Titles Act. Explanation. Scenario analysis. This scenario presents a common challenge in Alberta real estate where differing intentions regarding property ownership can lead to disputes if not clearly documented and understood. The professional challenge lies in advising clients accurately on the implications of various ownership structures and ensuring their chosen method aligns with their long-term goals and legal requirements under Alberta's Land Titles Act. Misunderstanding the nuances of joint tenancy versus tenancy in common can have significant consequences for inheritance, sale, and creditor claims. Correct approach analysis. The best professional approach involves clearly explaining the fundamental differences between joint tenancy and tenancy in common, specifically highlighting the right of survivorship inherent in joint tenancy and the separate, divisible interests in tenancy in common. This explanation should be tailored to the client's stated intentions for the property, emphasizing how each form of ownership would affect the disposition of their interests upon death or in the event of a sale. The professional must then ensure the chosen ownership structure is accurately reflected in the transfer documents submitted to Alberta's Land Titles Office, adhering to the requirements of the Land Titles Act. This ensures legal validity and aligns with the client's expressed wishes. Incorrect approach is analysis, advising the clients to simply register the property as joint tenants without a thorough discussion of the right of survivorship and its implications for their individual estate plans is a failure to provide adequate professional advice. This could lead to unintended consequences where one owner's interest automatically passes to the surviving owner, bypassing their intended beneficiaries. Suggesting that they register as tenants in common without clarifying the implications of undivided shares and the absence of survivorship is also professionally deficient. This could lead to confusion about how their respective shares will be dealt with upon their deaths, potentially creating disputes among heirs. Recommending that they leave the ownership structure ambiguous or rely on verbal agreements outside of the registered title is a critical failure. Alberta's Land Titles Act requires clear registration of ownership interests. Verbal agreements are not legally binding on title and can lead to significant legal battles and financial losses. Professional reasoning. Professionals should adopt a client-centric approach, beginning with active listening to understand the client's objectives. This should be followed by a clear, jargon-free explanation of relevant legal concepts, using Alberta-specific legislation as the basis for advice. Professionals must then guide clients in selecting the ownership structure that best meets their stated goals, ensuring all documentation accurately reflects this choice and complies with provincial regulations. A commitment to ongoing education on property law and best practices is essential. Question 8. Process analysis reveals a real estate professional in Alberta is listing a property that consists of 160 acres of land, featuring a substantial barn, extensive fencing, and a small farmhouse. The current owner primarily uses the land for raising cattle and growing hay for sale. What is the most appropriate classification for this property under Alberta's real estate framework? Option A. Industrial property. Option B. Agricultural land. Option C. Residential property. Option D. Commercial property. Correct answer is B. Agricultural land. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the real estate professional to accurately classify a property based on its primary use and intended purpose, which has significant implications for marketing, legal disclosures, and regulatory compliance under Alberta's real estate legislation. Misclassification can lead to misrepresentation, breach of contract, and potential disciplinary action. Careful judgment is required to distinguish between different property types, especially when a property might have characteristics of more than one category. Correct approach analysis. The best professional practice is to classify the property based on its predominant use and the primary intention of the current or prospective owner. In this case, the property is a large parcel of land with a barn and fencing, currently used for raising livestock and growing crops. This clearly aligns with the definition and typical characteristics of agricultural land. Alberta's Real Estate Act and associated regulations, along with industry best practices, emphasize accurate property classification for proper marketing and disclosure. Identifying it as agricultural land ensures that marketing efforts are targeted appropriately, and potential buyers are aware of the specific zoning, agricultural subsidies, and operational considerations associated with such properties. Incorrect approach is analysis. Classifying the property solely as residential would be incorrect because while it might have a dwelling, the primary economic activity and infrastructure, barn, fencing, land use, are not residential in nature. This misrepresents the property's core function and would mislead potential buyers seeking a residential home, failing to disclose crucial agricultural aspects. Classifying it as commercial would be incorrect, as commercial real estate typically involves businesses engaged in trade, services, or retail, which is not the primary function of this land. While farming is a business, The specific classification for land dedicated to primary production is agricultural. Classifying it as industrial would be incorrect because industrial properties are generally associated with manufacturing, processing, or warehousing of goods, which is not the use described. This classification would be entirely inappropriate for land used for livestock and crop cultivation. Professional reasoning. Professionals should employ a systematic approach to property classification. This involves 1. Understanding the definitions of different real estate types as per Alberta's legislation and common industry understanding. 2. Analyzing the property's physical characteristics and existing infrastructure. 3. Determining the primary use and the owner's or prospective buyer's intended use. 4. Considering zoning regulations and any specific provincial or municipal designations. 5. Consulting with relevant experts if there is ambiguity. The goal is always to provide accurate and transparent information to all parties involved. Question 9. During the evaluation of a client's potential property purchase in Calgary, Alberta, a real estate professional observes a significant increase in new housing starts and a corresponding rise in average sale prices over the past 6 months. The client is eager to make an offer, but is concerned about potential market fluctuations. Which of the following approaches best guides the professional's advice to the client regarding the current real estate cycle and its implications? Option A. Recommend proceeding with the purchase immediately, citing the recent price increases as a clear sign of a market peak and an opportunity to sell quickly in the future. Option B. Focus the discussion solely on historical sales data from the last 5 years in Calgary, assuming that past performance is the most reliable indicator of future market behavior. Option C. Advise the client based on general knowledge of real estate cycles, emphasizing that all markets experience ups and downs, without delving into specific Alberta data or current trends. Option D. Conduct a thorough analysis of current Alberta economic indicators, including employment, interest rates, and population migration, alongside recent sales data and inventory levels, to identify the probable phase of the real estate cycle and its potential impact on the client's decision. The correct answer is D. Conduct a thorough analysis of current Alberta economic indicators, including employment, interest rates, and population migration, alongside recent sales data and inventory levels to identify the probable phase of the real estate cycle and its potential impact on the client's decision. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate professional in Alberta because it requires them to interpret and apply knowledge of real estate market cycles to advise a client. Misinterpreting the current market phase or failing to adequately explain its implications can lead to poor client decisions, financial losses, and potential professional liability. The challenge lies in moving beyond simple observation to providing actionable, informed advice grounded in an understanding of economic indicators and their impact on property values and market activity within Alberta's specific context. Correct approach analysis. The best approach involves a comprehensive analysis of current economic indicators relevant to Alberta's real estate market, such as employment rates, interest rate trends, population growth, housing inventory levels, and recent sales data. This analysis should then be used to identify the most probable current phase of the real estate cycle, e.g., expansion, peak, contraction, trough, and to forecast potential future trends. The professional must then clearly communicate these findings and their implications to the client, explaining how the identified cycle phase might affect their buying or selling strategy, potential returns, and associated risks. This aligns with the ethical duty of care and the requirement under Alberta's real estate legislation to act in the best interests of the client by providing competent and informed advice. Incorrect approaches analysis. One incorrect approach involves making a recommendation based solely on anecdotal evidence or personal intuition about the market. This fails to meet the professional standard of care, as it lacks objective data and a systematic analysis of market cycles. Could lead to advice that is misaligned with the actual market conditions, potentially causing the client to overpay for a property or sell at an unfavorable price, violating the duty to act in the client's best interest. Another incorrect approach is to provide a generic overview of real estate cycles without tailoring it to Alberta's specific economic conditions and recent market data. While understanding general cycles is important, failing to apply this knowledge to the local context means the advice is not specific or actionable for the client's situation in Alberta. This demonstrates a lack of due diligence and can result in advice that is irrelevant or misleading. A further incorrect approach is to focus exclusively on past market performance without considering current trends and future projections. While historical data informs cycle analysis, relying solely on the past ignores the dynamic nature of real estate markets and current economic influences. This can lead to outdated advice that does not prepare the client for the realities of the present or near future market. Professional reasoning. Professionals should adopt a data-driven and client-centric approach. This involves 1. Gathering and analyzing relevant economic and real estate data specific to Alberta. 2. Identifying the current phase of the real estate cycle and potential future trajectories based on this analysis. 3. Clearly and comprehensively communicating the findings and their implications to the client, including potential risks and opportunities. 4. Tailoring advice to the client's specific goals and circumstances within the context of the identified market cycle. This systematic process ensures informed decision-making and upholds professional responsibilities. Question 10. What factors determine the most appropriate valuation methodology for a vacant, undeveloped parcel of land located in Calgary, Alberta, when preparing an appraisal for a potential sale? Option A. The cost to acquire similar undeveloped land in a different province and the potential for future appreciation based on economic forecasts. Option B. The availability of recent sales data for comparable vacant land parcels and the property's physical characteristics. Option C. The current market value of developed properties in the vicinity and the depreciation of existing structures. Option D. The potential for future rental income and the cost to develop the land into a commercial property. The correct answer is B. The availability of recent sales data for comparable vacant land parcels and the property's physical characteristics. Explanation. Scenario analysis. This scenario presents a common challenge in real estate valuation, where differing methodologies can lead to significantly different conclusions of value. The professional challenge lies in selecting the most appropriate valuation method based on the specific characteristics of the property and the purpose of the appraisal, ensuring compliance with Alberta's Real Estate Act and its associated regulations, as well as the Appraisal Institute of Canada, AIC, standards of practice. Misapplication of a valuation method can lead to an inaccurate market value, potentially causing financial harm to clients and violating professional ethical obligations. Correct approach analysis. The best professional practice involves selecting the valuation approach that is most relevant and reliable for the specific property type and market conditions. For a vacant, undeveloped parcel of land in Alberta, the sales comparison approach is generally the most appropriate and reliable method. This approach involves analyzing recent sales of comparable vacant land parcels, adjusting for differences in location, size, zoning, topography, and other relevant features. The Alberta Real Estate Act and AIC standards emphasize the importance of using the most suitable methodology to arrive at an accurate market value. This approach directly reflects current market activity for similar properties, providing the most direct evidence of value for undeveloped land. Incorrect approaches analysis. Using the income approach for a vacant, undeveloped parcel of land is inappropriate because there is no existing or potential income stream to analyze. This approach is designed for income-producing properties and would require speculative assumptions about future income, which is not supported by the property's current state. This violates the principle of using relevant data and can lead to a misleading valuation. Applying the cost approach to a vacant, undeveloped parcel of land is also fundamentally flawed. The cost approach estimates value based on the cost to replace or reproduce a property, less depreciation. For vacant land, there is no existing structure to consider the cost of, nor is there depreciation to account for. While the land value component of the cost approach is relevant for improved properties, it is not a standalone method for valuing vacant land itself. Relying on this method would ignore the direct market evidence available for vacant land. Professional reasoning. Professionals should approach valuation by first understanding the property's characteristics and the purpose of the appraisal. They should then consider the three primary valuation approaches: sales comparison, income, and cost, and determine which approach are most applicable and reliable given the property type and available market data. Regulatory requirements such as those in Alberta's Real Estate Act and professional standards like those from the AIC must guide this selection. A thorough comparative market analysis is crucial for the sales comparison approach, ensuring that adjustments are logical and supported by market evidence. When multiple approaches are used, a reconciliation process is necessary to arrive at a final opinion of value, with the most reliable approach typically carrying the most weight. Question 11. Stakeholder feedback indicates that a real estate brokerage in Alberta has received a written offer on a property listed by another brokerage. The offer is presented to the buyer's agent, who is affiliated with the brokerage that has the listing. What is the most professional and legally compliant course of action for the brokerage that received the competing offer? Option A. Advise the seller to reject the competing offer outright without presenting its terms and conditions to them. Option B. Contact the buyer directly who submitted the competing offer to discuss their willingness to increase their price without involving their agent. Option C. Hold on to the competing offer for a few days to see if the original offer is accepted or rejected before disclosing it. Option D. Immediately present the competing offer to the seller's brokerage, providing all necessary documentation, as per standard practice and Alberta's Real Estate Act rules. Correct answer is D. Immediately present the competing offer to the seller's brokerage, providing all necessary documentation as per standard practice and Alberta's Real Estate Act rules. Explanation. This scenario presents a professional challenge because it requires a brokerage to balance the fiduciary duty owed to a client with the need to maintain a positive and collaborative relationship with other brokerages in Alberta's real estate market. Mismanagement of this situation could lead to a breach of fiduciary duty, damage to the brokerage's reputation, and potential contravention of Alberta's Real Estate Act and its associated rules. Careful judgment is required to ensure all parties are treated ethically and professionally, while upholding the client's best interests. The best approach involves direct and transparent communication with the seller's brokerage. This means promptly informing them of the competing offer and providing the necessary documentation as per standard practice and the Alberta Real Estate Act rules. This approach is correct because it adheres to the fiduciary duty of loyalty and disclosure to the client by ensuring they are fully aware of all offers. It also upholds professional conduct by treating the other brokerage and their client with respect and transparency, fostering a fair and orderly transaction process. This aligns with the principles of honesty and integrity expected of licensed real estate professionals in Alberta. An incorrect approach would be to ignore the competing offer or delay informing the seller's brokerage. This failure to disclose a material fact, the existence of another offer, directly breaches the fiduciary duty owed to the seller and contravenes the Alberta Real Estate Act rules regarding disclosure of offers. Another incorrect approach would be to attempt to negotiate directly with the buyer without the seller's explicit instruction and without involving the seller's brokerage. This bypasses the listing brokerage, potentially creating conflict and violating professional courtesy and established practice, and could be seen as interfering with another brokerage's client relationship. Furthermore, attempting to pressure the seller to reject the competing offer without full disclosure of its terms and implications would also be an ethical and regulatory failure, as it prioritizes the brokerage's potential gain over the seller's informed decision-making. Professionals should approach such situations by first understanding their fiduciary obligations to their client. This involves a commitment to full disclosure and acting in the client's best interest. They should then consider the professional standards and ethical guidelines governing real estate practice in Alberta, which emphasize honesty, integrity, and fair dealing. When a competing offer arises, the immediate step should be to inform the client and their listing brokerage promptly and professionally, facilitating a transparent and competitive process that respects all parties involved. Question 12. Strategic planning requires a real estate investor in Alberta to consider various financing avenues. If an investor, new to the market, expresses interest in options that can facilitate quicker property acquisition, but has limited knowledge of their intricacies, what is the most prudent course of action for their real estate professional? Option A. Recommend seller financing as a simple solution, focusing on the potential for flexible terms without fully disclosing the seller's retained interests or the investor's future financing challenges. Option B. Provide a detailed explanation of the characteristics, risks, and typical terms of both hard money loans and seller financing, emphasizing the need for independent legal and financial advice before commitment. Option C. Advise the investor to proceed with the option that offers the lowest upfront costs, regardless of the long-term financial implications or the complexity of the loan structure. Option D. Strongly advocate for hard money loans, highlighting their speed of closing and downplaying the associated high interest rates and short repayment periods. The correct answer is B. Provide a detailed explanation of the characteristics, risks, and typical terms of both hard money loans and seller financing, emphasizing the need for independent legal and financial advice before commitment. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate professional in Alberta because it involves advising an investor on financing options that carry significant risk and require a thorough understanding of both the Alberta Real Estate Act and its associated regulations, as well as ethical obligations. The investor's limited experience and reliance on the professional's guidance necessitate a high degree of diligence and transparency. Misrepresenting or failing to adequately disclose the risks associated with hard money loans or seller financing could lead to significant financial harm for the investor and professional repercussions for the agent. Correct approach analysis. The best professional practice involves thoroughly explaining the nature, risks, and typical terms of both hard money loans and seller financing, specifically within the context of Alberta's real estate market. This includes detailing the higher interest rates and shorter repayment terms common with hard money loans, and the potential for the seller to retain an interest in the property or face difficulties in recouping their investment with seller financing. Crucially, the professional must emphasize that these are not traditional mortgage products and require careful due diligence on the part of the investor to understand the loan covenants, repayment schedules, and potential for foreclosure. The professional must also advise the investor to seek independent legal and financial advice before committing to either option, aligning with the fiduciary duty to act in the client's best interest and the Alberta Real Estate Act's requirement for agents to be honest and truthful. Incorrect approaches analysis. Recommending hard money loans without a comprehensive explanation of their high costs and short terms, and without advising independent legal counsel, is professionally unsound. This approach fails to adequately inform the investor of the significant risks, potentially leading to default and financial distress, which violates the duty of care and honesty. Suggesting seller financing as a straightforward alternative without detailing the potential complexities, such as the seller's ongoing interest in the property or the investor's potential inability to secure traditional financing later, is also problematic. This omission can mislead the investor about the true nature and long-term implications of the arrangement, breaching the duty to provide accurate and complete information. Focusing solely on the speed of closing with hard money loans, while downplaying the associated costs and risks, demonstrates a prioritization of transaction expediency over the investor's financial well-being. This neglects the professional's ethical obligation to ensure the client makes informed decisions based on a full understanding of all relevant factors, including potential downsides. Professional reasoning. Professionals should approach financing discussions by first understanding the investor's financial capacity, risk tolerance, and investment goals. They must then provide a balanced overview of available financing options, clearly articulating the advantages and disadvantages of each, with a particular emphasis on the risks inherent in non-traditional financing, like hard money loans and seller financing. This includes explaining the terms, costs, and potential consequences of default. A critical step is always to advise the investor to consult with independent legal and financial professionals to ensure they fully comprehend the agreements and their implications before proceeding. This layered approach ensures informed consent and protects both the investor and the real estate professional. Question 13. Quality control measures reveal that a licensed real estate broker in Alberta has been representing a seller in a property listing. During the listing period, the broker learns that a close personal friend, with whom they have a long-standing relationship, is very interested in purchasing a property in the same neighborhood and has expressed a strong desire to buy the seller's property. The broker has not yet disclosed this personal connection to their seller client. What is the most appropriate course of action for the broker to take in this situation? Option A. Immediately disclose the personal relationship with the potential buyer to the seller in writing, clearly outlining the nature of the connection and its potential implications, and obtain the seller's informed written consent before proceeding further with any offer from the friend. Option B. Advise the friend to make an offer through another brokerage to avoid any appearance of impropriety, without informing the seller about the broker's prior relationship with the friend. Option C. Inform the seller verbally about the friend's interest but proceed with the transaction without obtaining written consent, as the relationship is not direct financial involvement for the broker. Option D. Proceed with the transaction if the friend makes an offer, assuming the friend will act in their own best interest and the seller will conduct their own due diligence. Correct answer is A. Immediately disclose the personal relationship with the potential buyer to the seller in writing, clearly outlining the nature of the connection and its potential implications, and obtain the seller's informed written consent before proceeding further with any offer from the friend. Explanation. This scenario presents a professional challenge because it requires a real estate broker to balance the fiduciary duty owed to their client with the legal and ethical obligations to ensure fair and transparent dealings in the Alberta real estate market. The broker must act with integrity and competence, avoiding any actions that could be construed as misrepresentation or a conflict of interest, all while navigating the complexities of a potentially lucrative but ethically sensitive transaction. Careful judgment is required to uphold professional standards and protect all parties involved. The best professional approach involves the broker proactively disclosing the potential conflict of interest to their client in writing, clearly outlining the nature of the relationship with the potential buyer and the implications for the transaction. This approach is correct because it aligns with the principles of transparency and honesty mandated by the Real Estate Act, Alberta, and its associated rules. Specifically, Section 42 of the Real Estate Act, Alberta, and relevant sections of the Real Estate Council of Alberta, RECA, Code of Ethics require registrants to disclose any potential conflicts of interest to their clients. By obtaining informed consent from the client after full disclosure, the broker upholds their fiduciary duty and demonstrates professional integrity, ensuring the client can make an informed decision about proceeding with the transaction. An incorrect approach would be to proceed with the transaction without any disclosure, hoping the relationship remains undiscovered. This is ethically unacceptable and a violation of the Real Estate Act, Alberta, and RECA Code of Ethics, as it constitutes a failure to disclose a material fact and a potential conflict of interest, thereby breaching the duty of honesty and integrity owed to the client. Another incorrect approach would be to inform the client verbally, but not document the disclosure or the client's consent. While better than no disclosure, this still falls short of best practice and regulatory requirements. The Real Estate Act, Alberta, and RECA rules emphasize written disclosure and consent for significant matters like conflicts of interest, providing clear evidence of the broker's adherence to their obligations and protecting both the client and the broker. Proceeding with the transaction by having the buyer submit an offer through a different brokerage, without the client's explicit knowledge and consent regarding the broker's prior relationship with the buyer, is also an unacceptable approach. This attempts to circumvent the disclosure requirement rather than address it directly and ethically. It fails to uphold the principle of full disclosure and could be seen as facilitating a transaction under false pretenses, undermining the integrity of the real estate process in Alberta. Professionals should adopt a decision-making framework that prioritizes transparency, honesty, and adherence to regulatory requirements. When faced with a potential conflict of interest, the first step is to identify it. Subsequently, the professional must consult the relevant legislation and professional codes of conduct, in this case, the Real Estate Act, Alberta, and RECA Code of Ethics. The next step is to proactively disclose the conflict in writing to all affected parties, explaining its nature and implications. Obtaining informed, written consent is crucial before proceeding. If consent cannot be obtained, or if the conflict cannot be adequately managed, the professional must consider withdrawing from the transaction to maintain ethical and legal compliance. Question 14. The assessment process reveals that a licensed real estate professional in Alberta has been approached by a seller to list their property, and shortly thereafter, by a buyer who is interested in purchasing that same property. The professional believes they can facilitate this transaction, but is unsure of the proper procedure to ensure compliance with Alberta's real estate regulations. What is the most appropriate course of action for the professional in this situation? Option A. Proceed with representing the seller and disclose to the buyer that the professional is acting solely for the seller, hoping the buyer will proceed with their offer. Option B. Obtain written informed consent from both the seller and the buyer after fully disclosing the nature of dual agency, including the limitations on representation and the agent's neutral role, and explaining all material facts known to them. Option C. Facilitate the transaction by acting as a neutral third party without obtaining explicit consent for dual agency, assuming that by not favoring either party, they are acting ethically. Option D. Represent the buyer exclusively and disclose to the seller that the professional is acting solely for the buyer, hoping the seller will accept the buyer's offer. The correct answer is B. Obtain written informed consent from both the seller and the buyer after fully disclosing the nature of dual agency, including the limitations on representation and the agent's neutral role, and explaining all material facts known to them. Explanation. The assessment process reveals a scenario where a real estate professional in Alberta is tasked with representing both the seller and the buyer in the same transaction. This situation is professionally challenging because it inherently creates a conflict of interest. The agent has a fiduciary duty to both parties, requiring them to act in the best interests of each. However, the seller's best interest is typically to achieve the highest possible price and most favorable terms, while the buyer's best interest is to secure the property at the lowest possible price and most favorable terms. Balancing these opposing interests requires meticulous adherence to provincial regulations and ethical standards to maintain fairness and transparency. The correct approach involves obtaining informed consent from both parties for dual agency, clearly outlining the limitations of representation and the agent's neutral role. In Alberta, this is governed by the Real Estate Act and its associated rules. The agent must explain that they can no longer advocate for one party's specific interests over the other. They must disclose all material facts known to them that might influence either party's decision. This approach is correct because it prioritizes transparency, informed consent, and compliance with the Real Estate Act, Alberta, which mandates disclosure and prohibits misrepresentation or fraud. By obtaining written consent after full disclosure, the agent mitigates the inherent conflict and upholds their professional obligations. An incorrect approach would be to proceed with representing both parties without full disclosure and informed consent. This failure to disclose the conflict of interest and the limitations of representation violates the agent's fiduciary duties and contravenes the Real Estate Act, Alberta. Such an action could lead to accusations of misrepresentation or fraud, as the agent is not acting solely in the best interest of each party. Another incorrect approach is to prioritize one party's interests over the other while claiming to represent both. This is a direct breach of the agent's duty to act impartially in a dual agency situation and violates the principles of fair dealing required by the Real Estate Act, Alberta. The agent's role shifts from advocate to facilitator, and any attempt to favor one party undermines the integrity of the transaction and the professional's standing. Finally, an incorrect approach is to withdraw from representing one party without proper notification and explanation, or to attempt to act as a dual agent without understanding the specific disclosure and consent requirements. This can leave both parties feeling misled and unprotected, potentially leading to legal and professional repercussions. Professionals should approach dual agency situations with extreme caution. The decision-making process should begin with an assessment of whether dual agency is even permissible and advisable given the specific circumstances and the nature of the property and parties involved. If proceeding, the agent must immediately initiate a thorough disclosure process, ensuring both parties fully understand the implications, limitations, and their rights. Obtaining written, informed consent is paramount. Throughout the transaction, the agent must maintain strict impartiality, disclosing all material information to both parties equally and avoiding any action that could be perceived as favoring one over the other. Question 15. The monitoring system demonstrates that a seller in Calgary, Alberta, who previously signed an exclusive right to sell listing agreement with your brokerage, has expressed a desire to explore other real estate agents and potentially list their property with a different brokerage. They are asking for advice on how to proceed without incurring penalties. What is the most appropriate course of action for the real estate professional? Option A. Suggest to the seller that they can simply ignore the exclusive right to sell agreement and pursue other agents freely, as their dissatisfaction is evident. Option B. Cease all marketing activities for the property immediately, as the seller's expressed interest suggests a lack of commitment to the current brokerage. Option C. Explain to the seller that under the exclusive right to sell agreement, the brokerage is entitled to a commission if the property sells during the agreement term, regardless of who finds the buyer, and discuss the terms of the agreement regarding early termination, ensuring all actions are documented and compliant with Alberta's Real Estate Act. Option D. Advise the seller to immediately list the property with another agent, as their expressed interest indicates a desire to move on, and assume the previous agreement will be amicably dissolved. Correct answer is C. Explain to the seller that under the exclusive right to sell agreement, the brokerage is entitled to a commission if the property sells during the agreement term, regardless of who finds the buyer, and discuss the terms of the agreement regarding early termination, ensuring all actions are documented and compliant with Alberta's Real Estate Act. Explanation: the monitoring system demonstrates a common but potentially complex situation in real estate transactions, where a seller's intentions might evolve after signing an agreement. The professional challenge lies in navigating the seller's desire to explore other options while upholding the terms of the existing contract and adhering to Alberta's real estate regulations. Misinterpreting the seller's wishes or the implications of the listing agreement could lead to breaches of contract, ethical violations, and potential legal repercussions for the brokerage. The best professional approach involves clearly understanding the seller's current listing agreement and advising them on their obligations and options within that framework. If the seller has signed an exclusive right to sell agreement, the brokerage has the sole right to earn a commission if the property sells, regardless of who finds the buyer. In this scenario, the brokerage should explain to the seller that while they are free to explore other avenues, the exclusive right to sell agreement remains in effect. The brokerage's duty is to continue marketing the property diligently and to inform the seller of any offers received. If the seller wishes to terminate the agreement prematurely, the brokerage must explain the potential consequences as outlined in the agreement, such as a termination fee, and ensure any such termination is handled formally and in writing, adhering to the terms of the Alberta Real Estate Act and its associated regulations. This approach prioritizes transparency, contractual integrity, and client education, fulfilling the brokerage's fiduciary duties. An incorrect approach would be to immediately agree to list the property with another brokerage without addressing the existing exclusive right to sell agreement. This would violate the terms of the current agreement, potentially exposing the seller to paying 2 commissions and the brokerage to disciplinary action for acting in bad faith and misrepresenting the property's listing status. It also fails to uphold the brokerage's obligation to the original seller under the existing contract. Another incorrect approach would be to advise the seller that they can simply ignore the exclusive right to sell agreement and pursue other options without consequence. This is a misrepresentation of the legal and contractual obligations. The seller is bound by the terms of the agreement, and advising them otherwise would be unethical and contrary to the principles of contract law and the Real Estate Act. Finally, an incorrect approach would be to cease all marketing efforts for the property, because the seller expressed interest in exploring other options. Under an exclusive right to sell agreement, the brokerage is obligated to continue marketing the property and to act in the seller's best interest to secure a sale. Abandoning marketing efforts would be a breach of this duty. The professional reasoning process for a real estate professional in such a situation should involve 1. Thoroughly reviewing the existing listing agreement to understand its terms and conditions. 2. Engaging in open and honest communication with the seller to understand their motivations and concerns. 3. Clearly explaining the seller's contractual obligations and the brokerage duties under the current agreement. 4. Advising the seller on all available legal and ethical options, including the implications of any proposed changes to the listing status. 5. Documenting all discussions and agreements in writing. Question 16. Market research demonstrates that a significant number of first-time homebuyers in Alberta are seeking financing with down payments below the 20% threshold. When a buyer expresses concern about the additional cost of private mortgage insurance, PMI, on their potential mortgage, what is the most appropriate course of action for a licensed real estate professional in Alberta? Option A. Explain that PMI is a lender requirement designed to protect the lender, not the buyer, and advise the buyer to discuss the specific costs and implications directly with their mortgage lender. Option B. Assure the buyer that PMI is a nominal fee that will have a negligible impact on their monthly mortgage payments and is a standard part of obtaining a mortgage with a smaller down payment. Option C. Advise the buyer that the seller may be willing to contribute to the PMI cost to facilitate the sale, or that the real estate professional can negotiate a reduction in the PMI premium with the lender. Option D. Recommend a specific mortgage product from a particular lender that is known to have lower PMI rates based on general market knowledge to help the buyer manage this additional expense. The correct answer is A. Explain that PMI is a lender requirement designed to protect the lender, not the buyer, and advise the buyer to discuss the specific costs and implications directly with their mortgage lender. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate professional in Alberta to navigate the complexities of private mortgage insurance, PMI, in the context of a buyer's financial situation and lender requirements. The professional must balance the client's desire for a specific property with the lender's risk assessment, which directly impacts the availability and cost of financing. Misunderstanding or misrepresenting PMI can lead to significant financial and legal repercussions for both the client and the professional. Correct approach analysis. The best professional approach involves clearly explaining to the buyer that PMI is a requirement imposed by the lender, not the seller or the real estate professional, when a down payment is less than 20% of the purchase price. This explanation should detail that PMI protects the lender against potential default by the borrower. The professional must then advise the buyer to consult directly with their chosen mortgage lender to understand the specific PMI costs, terms, and how it will be factored into their overall mortgage payments. This approach is correct because it adheres to the principles of transparency and client education, ensuring the buyer makes informed decisions based on accurate information from the financial institution underwriting the mortgage. It also respects the distinct roles of the real estate professional, facilitating the transaction, and the mortgage lender, assessing risk and providing financing. Incorrect approach is analysis. One incorrect approach is to suggest that the seller might be able to negotiate the removal of PMI, or that the real estate professional can influence the lender's PMI decision. This is professionally unacceptable because the real estate professional has no authority to alter the lender's underwriting requirements or negotiate PMI terms. This misleads the buyer into believing there are avenues for negotiation that do not exist, potentially causing them to delay or abandon the purchase based on false hope. Another incorrect approach is to downplay the significance of PMI, stating it's a minor cost that won't substantially affect the mortgage payment. This is ethically problematic, as it fails to provide the buyer with a complete and accurate picture of their financial obligations. PMI is a material cost that impacts the borrower's monthly payments and the total cost of borrowing, and understating its impact can lead to a buyer overextending their finances. A third incorrect approach is to recommend a specific mortgage product or lender based on their PMI rates without a thorough understanding of the buyer's overall financial profile and the lender's specific underwriting criteria. This could be seen as providing financial advice, which is outside the scope of a real estate professional's license and expertise, and could lead to the buyer obtaining a mortgage that is not in their best financial interest. Professional reasoning. Professionals should always prioritize clear, accurate, and transparent communication with their clients. When dealing with financing-related matters like PMI, the professional's role is to educate the client about the process and facilitate their engagement with the appropriate financial experts. This involves understanding the general requirements of mortgage lending in Alberta, such as the typical down payment thresholds that trigger PMI, but refraining from offering financial advice or making representations about lender-specific policies. The decision-making framework should involve identifying the client's needs, understanding the relevant regulatory landscape, in this case, mortgage lending practices in Alberta, clearly defining professional boundaries, and directing the client to the appropriate professionals, e.g., mortgage brokers, lenders, for specialized advice. Question 17. System analysis indicates that a client in Alberta is seeking real estate investment opportunities that offer passive income with minimal direct management involvement. They have expressed a moderate risk tolerance, considering the characteristics of real estate investment trusts rate, which approach best assesses their suitability for this client. Option A. Emphasize the potential for consistent passive income and tax benefits associated with rate. Assuming these advantages outweigh any potential market fluctuations for a client seeking minimal management. Option B. Recommend a specific rate based on its strong historical dividend payouts and recent capital appreciation, without extensively detailing the underlying real estate market risks. Option C. Conduct a detailed risk assessment that explicitly outlines the specific risks of rate, such as market volatility, interest rate sensitivity, and management fees, and directly compares these to the client's stated risk tolerance and investment objectives. Option D. Advise the client that rate are a low-risk investment because they are diversified and publicly traded, similar to blue-chip stocks, and therefore suitable for moderate risk tolerance. Correct answer is C. Conduct a detailed risk assessment that explicitly outlines the specific risks of rate, such as market volatility, interest rate sensitivity, and management fees, and directly compares these to the client's stated risk tolerance and investment objectives. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate professional in Alberta to assess the suitability of a real estate investment trust rate for a client, balancing the client's stated risk tolerance with the inherent characteristics of rate. The challenge lies in accurately communicating the specific risks associated with rate, which can differ from direct property ownership, and ensuring the client's understanding is not based on oversimplified assumptions. The professional must navigate potential conflicts between a client's desire for passive income and their actual capacity to absorb market volatility. Correct approach analysis. The best professional approach involves a thorough risk assessment that explicitly identifies and explains the unique risks associated with rate, such as market volatility, interest rate sensitivity, and management fees, and then directly compares these to the client's stated risk tolerance and investment objectives. This approach ensures that the client receives comprehensive and tailored advice, enabling them to make an informed decision. This aligns with the ethical obligations under Alberta's real estate regulations and professional conduct rules, which mandate acting in the client's best interest and providing advice that is suitable and well substantiated. It requires the professional to go beyond a general understanding of rate and delve into how their specific characteristics interact with the client's financial situation and risk profile. Incorrect approaches analysis. One incorrect approach involves focusing solely on the potential for passive income and tax advantages of rate without adequately detailing the associated market risks. This fails to meet the professional obligation to provide a balanced and complete picture, potentially misleading the client into believing rate are a risk-free income stream. This omission constitutes a failure to act in the client's best interest and could be seen as a breach of the duty of care. Another incorrect approach is to recommend a rate based on its historical performance alone, without considering current market conditions or the client's specific circumstances. Past performance is not indicative of future results, and relying on it without a broader risk assessment ignores the dynamic nature of the investment landscape and the client's individual needs. This approach lacks due diligence and fails to provide prudent advice. A further incorrect approach is to assume that because rate are publicly traded, they carry the same risk profile as individual stocks. While both are subject to market fluctuations, rate have specific underlying asset risks, real estate market downturns, property-specific issues, and are also influenced by factors like interest rate changes in ways that may differ from a typical corporation. This oversimplification can lead to a mischaracterization of risk and inappropriate recommendations. Professional reasoning. Professionals should adopt a client-centric risk assessment framework. This involves first understanding the client's financial situation, investment goals, and risk tolerance in detail. Second, they must possess a deep understanding of the investment products being considered, including their specific risk factors, potential returns, and regulatory implications within Alberta. Third, they must be able to clearly articulate these risks and benefits to the client in a manner that is easily understood, facilitating informed consent. The process requires a proactive approach to identifying potential conflicts and ensuring that advice is always aligned with the client's best interests, adhering to the principles of disclosure and suitability mandated by Alberta's real estate and securities regulatory bodies. Question 18. The evaluation methodology shows that an Alberta real estate licensee is assisting a client with a mortgage application. The client states they have a new job starting next month with a significant salary increase, and also mentions they have a substantial credit card debt they are confident they can manage. The client urges the licensee to submit the application immediately with their current employment details and to omit the credit card debt, assuring the licensee that everything will be fine. Which approach best reflects the licensee's professional obligations and regulatory requirements in Alberta? Option A. Submit the mortgage application using the client's current employment details and verbally assure the lender about the upcoming new job and salary. Option B. Submit the mortgage application with the client's current employment information and omit the credit card debt, relying on the client's assurance that they can manage it. Option C. Include the client's stated intention to start a new business as guaranteed income in the application to demonstrate higher earning potential. Option D. Verify the client's new employment details and salary through independent means. Request documentation for the credit card debt and submit a complete and accurate application to the lender, disclosing all relevant financial information. The correct answer is D. Verify the client's new employment details and salary through independent means. Request documentation for the credit card debt and submit a complete and accurate application to the lender, disclosing all relevant financial information. Explanation. Scenario analysis. This scenario presents a professional challenge for an Alberta real estate licensee because it requires them to balance the client's immediate desire for a mortgage approval with the lender's need for accurate and complete information to conduct a thorough risk assessment. Misrepresenting information, even with the client's consent, can lead to serious regulatory breaches, financial penalties, and damage to the licensee's reputation and the integrity of the mortgage market. The licensee must navigate the ethical obligation to their client with the legal and professional duty to be truthful and transparent with the lender. Correct approach analysis. The best professional approach involves diligently verifying all information provided by the client and ensuring its accuracy before submitting the mortgage application. This includes confirming employment details, income sources, and asset valuations through independent means where possible or by requesting supporting documentation. The licensee must then present this verified information to the lender, clearly disclosing any potential concerns or discrepancies that were identified and resolved. This approach aligns with the principles of honesty, integrity, and due diligence mandated by the Real Estate Council of Alberta (RECA) and the Mortgage Brokers Act of Alberta. It ensures that the lender receives a true and fair representation of the applicant's financial situation, enabling them to make an informed lending decision and mitigating risks for all parties involved. Incorrect approaches analysis. Submitting the application with the client's verbal assurance of employment without independent verification is professionally unacceptable. This fails to meet the standard of due diligence required by RECA. Lenders rely on verified information, and submitting unconfirmed details exposes the licensee to accusations of misrepresentation, which can lead to disciplinary action under the Real Estate Act, including the client's stated but unverified intention to start a new business as guaranteed income, is also a significant ethical and regulatory failure. Alberta's mortgage regulations and RECA Code of Ethics prohibit the submission of speculative or unproven income. This misrepresents the applicant's financial stability and can lead to mortgage default, with severe consequences for the licensee, including fines and license suspension. Failing to disclose the client's significant credit card debt to the lender, even if the client believes they can manage it, constitutes a material omission. The Mortgage Brokers Act requires full disclosure of all relevant financial information that could impact a borrower's ability to repay a loan. Withholding this information misleads the lender about the applicant's debt-to-income ratio and overall financial risk, violating professional standards and potentially leading to severe penalties. Professional reasoning. Professionals in Alberta's real estate and mortgage sectors must adopt a risk-based approach to client interactions and applications. This involves proactively identifying potential risks associated with a client's financial situation or the information provided. The decision-making process should prioritize accuracy, transparency, and adherence to regulatory requirements. When faced with incomplete or potentially misleading information, the professional's duty is to seek clarification and verification, not to proceed with assumptions or misrepresentations. Ethical conduct and regulatory compliance should always supersede a client's immediate desires if those desires conflict with professional obligations. A robust process includes obtaining supporting documentation, verifying employment and income independently, and ensuring full disclosure of all financial obligations to the lender. Question 19. Market research demonstrates that a significant portion of mortgage defaults in Alberta are linked to borrowers overextending their financial capacity. A client in Calgary is eager to purchase a property and has obtained a mortgage pre-approval. As their real estate professional, what is the most prudent approach to financing risk assessment? Option A. Conduct a thorough assessment of the client's debt-to-income ratio, employment stability, and the property's market value to determine their long-term ability to service the mortgage, in addition to reviewing the lender's pre-approval. Option B. Focus on securing the highest possible mortgage amount for the client to maximize their purchasing power, as this is their primary objective. Option C. Advise the client to proceed with the purchase if they express strong desire, downplaying any concerns about their existing debt load or employment stability. Option D. Rely solely on the lender's pre-approval, assuming it represents a complete assessment of the client's financial suitability for the mortgage. The correct answer is A. Conduct a thorough assessment of the client's debt-to-income ratio, employment stability, and the property's market value to determine their long-term ability to service the mortgage, in addition to reviewing the lender's pre-approval. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate professional to balance the client's immediate financial needs with the long-term implications of a financing decision, particularly concerning potential risks that could impact the client's ability to repay the mortgage. Alberta's real estate financing landscape, governed by provincial legislation and federal mortgage lending rules, necessitates a thorough understanding of risk assessment to protect both the client and the integrity of the transaction. A failure to adequately assess risk can lead to a client defaulting on their mortgage, resulting in financial hardship for the client and potential liability for the professional. Correct approach analysis. The best professional approach involves conducting a comprehensive risk assessment that goes beyond the borrower's credit score and income. This includes evaluating the borrower's debt-to-income ratio, employment stability, the property's market value and potential for appreciation or depreciation, and any other factors that could affect repayment capacity. In Alberta, real estate professionals are bound by the Real Estate Act and its associated rules, which mandate acting in the best interests of the client. This includes providing advice that is informed and considers potential risks. A thorough risk assessment aligns with the ethical obligation to ensure the client understands the financial commitments and potential challenges associated with their chosen mortgage product. Incorrect approach is analysis. One incorrect approach is to solely rely on the lender's pre-approval as sufficient due diligence. While a pre-approval indicates a lender's initial willingness to lend, it does not absolve the real estate professional of their responsibility to conduct their own independent risk assessment. This approach fails to consider factors beyond the lender's criteria, such as the client's overall financial health and the property's specific risks, potentially leading to a client taking on a mortgage they cannot comfortably manage. This contravenes the duty to act in the client's best interest as outlined in Alberta's real estate regulations. Another incorrect approach is to prioritize securing the highest possible loan amount for the client without adequately assessing their ability to service that debt. This might seem beneficial to the client in the short term, allowing them to purchase a more expensive property, but it significantly increases the risk of default if the client's financial situation changes. Alberta's regulatory framework emphasizes responsible lending practices and client protection, making an approach that solely focuses on maximizing loan size without commensurate risk evaluation a failure of professional duty. A third incorrect approach is to overlook potential red flags in the client's financial history, such as a history of late payments or significant unsecured debt, simply because the client expresses strong desire for a particular property. Ignoring such indicators, even if the client is insistent, is a dereliction of the professional's duty to provide sound advice. The Real Estate Act and its rules require professionals to exercise reasonable care and skill, which includes identifying and advising on potential financial risks that could jeopardize the client's investment and financial stability. Professional reasoning. Professionals should adopt a systematic risk assessment framework. This involves gathering all relevant financial information from the client, analyzing their debt-to-income ratio, assessing employment stability, and understanding their overall financial obligations. Concurrently, they must evaluate the property itself for any market-related risks. This comprehensive approach ensures that the advice provided is not only aligned with the client's stated goals, but also grounded in a realistic understanding of their capacity to meet their mortgage obligations, thereby fulfilling ethical and regulatory requirements in Alberta. Question 20. The control framework reveals a landlord in Alberta is preparing a lease agreement for a new tenant. The monthly rent is set at $1,800. The tenant is scheduled to move in on March 15, 2024. What is the correct prorated rent the tenant will owe for the month of March 2024, assuming the lease agreement does not specify an alternative proration method? Option A, $870.97. Option B, $900.00. Option C, $871.00. Option D, $1,800.00. The correct answer is A, $870.97. Explanation. The control framework reveals a scenario that is professionally challenging due to the potential for misinterpretation of lease terms and the financial implications for both the landlord and the tenant. Careful judgment is required to ensure accurate calculations and adherence to the Alberta Residential Tenancies Act, RTA. The best professional practice involves accurately calculating the prorated rent for the partial month based on the number of days in that specific month, as per standard Alberta rental practices and the principles of fair apportionment. This approach ensures that the tenant pays for the exact number of days they occupy the property during the partial month, aligning with the spirit of the lease agreement and common industry standards in Alberta. The calculation should be based on the daily rental rate derived from the monthly rent. An incorrect approach would be to prorate the rent based on a 30-day month, regardless of the actual number of days in the month. This fails to accurately reflect the actual occupancy period and can lead to either the tenant overpaying or underpaying for their use of the property, potentially creating disputes and violating the principle of fair rent. Another incorrect approach would be to round the prorated rent to the nearest whole dollar amount without explicit agreement. This introduces an arbitrary element into the calculation and deviates from the precise apportionment of rent based on the number of days occupied. It could result in a financial discrepancy that is not justified by the lease terms or the RTA. A further incorrect approach would be to charge the tenant the full monthly rent for the partial month of occupancy. This is a clear overcharge and directly contradicts the principle of paying for actual usage. It would be a violation of the tenant's rights and could lead to legal challenges under the Alberta Residential Tenancies Act. Professionals should employ a decision-making framework that prioritizes accuracy, fairness, and compliance with provincial legislation. This involves 1. Understanding the specific terms of the lease agreement regarding rent calculation for partial months. 2. Identifying the exact number of days in the relevant month. 3. Calculating the daily rent by dividing the monthly rent by the number of days in that month. 4. Multiplying the daily rent by the number of days the tenant will occupy the property during the partial month. 5. Documenting the calculation clearly for both parties.